In today's unbelievable courtroom showdown, two self-proclaimed sovereign citizens step in front of a judge, and what happens next will leave you stunned. The first case starts with a man facing serious domestic violence charges. But instead of focusing on the accusations, he launches into a series of bizarre legal claims. He insists he's a natural person, a Moroccan-American national, and even references an old treaty from the 1800s, arguing that the court has no authority over him. The judge, calm but clearly unimpressed, refuses to entertain the arguments. A not guilty plea is entered on his behalf, and strict bond conditions are set, including a no-contact order and a ban from returning to the shared home. When he resists providing fingerprints and biometric data, the court makes it clear, compliance is not optional. The booking process will happen before any release. Just when you think it can't get more intense, the second case begins. Another defendant is offered a pre-trial intervention program, a deal that could lead to dismissed charges if completed successfully. But instead of accepting what many would consider a lucky break, he refuses. He claims he doesn't agree with the terms and repeatedly questions the court's jurisdiction. The judge quickly shuts it down, reminding him that the state, not the defendant, decides whether charges move forward. With that, the case is set for trial. Throughout the hearing, frustration builds as these unconventional arguments go nowhere. The courtroom exchange becomes a powerful reminder that these sovereign citizen tactics, no matter how confidently delivered, consistently fail, and often make the legal consequences even worse. This is a real-life courtroom drama you have to see to believe.
I can place my status on the record if you like.
Yeah, hold on one sec. Yeah, I'll get to you 1 second. I need to look over some things. Are you representing yourself?
No, sir, I'm not representing myself. I'm presenting myself.
Okay. I mean, do you have is a court-appointed attorney going to be speaking with you, or are you going to have a retained attorney?
No, sir.
Okay, calling case Tom King 25 William Boy 00474 in the matter of Roman Curtis Campbell. Mr. Campbell, would you please state your name for the record?
Yeah, I like to state
Just tell me your
name.
Yeah, go ahead. Yeah, all I have to do is say it.
I'm Roman Curtis Campbell, a natural person for life.
Okay, let me ask you this question, Mr. Campbell. Let's try not to talk together. I mean, I'm going to allow you plenty of time to talk, but I have to. But are you representing yourself here today? You don't need an attorney, or you want an attorney?
No, sir. I'm not representing myself. I'm presenting myself. I don't need another man to present.
Are you presenting yourself? So you don't want an attorney, you're presenting yourself here today. Is that correct?
Yes, sir.
Okay. All right. Thank you, sir, for that.
You're welcome.
You're charged with domestic violence, as I've indicated. MCL 750.81, it carries a maximum penalty of 93 days in jail, possible fines of $500 and/or both, not including any court costs. I am going to enter a plea on your behalf of not guilty on this offense. You will be given an additional, and you're also charged with refusal for collecting fingerprints and data, which the court is ordering that you do that. As I've indicated, I'm entering a plea of not guilty on your behalf for this matter. I'll indicate that you're self-representing at this time as well. I do have some other conditions for you before I set bond. You're not to have any direct or indirect contact with Marissa, Maurissa Smith. You're not to return to the premises known as Celeste Road.
That's my home.
Yeah. I'm gonna keep going, and then I'm gonna take all your questions at the end. So no problem. It's not. Just hold on to. You're gonna have plenty of time to talk at the end. So do not return to the premises known as Road, West Bloomfield. You will not assault, beat, verbally harass, intimidate, or threaten any potential witnesses. Person may appear for all court proceedings Do not leave the state of Michigan without permission of the court, and immediately notify the court in writing of any change of address or phone number. You need to provide the court with a valid address within 24 hours of your release. Do not leave the state of Michigan without permission of the court. You will not possess any firearms or other dangerous weapons. You shall refrain from using alcohol, any form of THC, illegal drugs, or using any medication. You must contact pretrial services within 24 hours of your release. That's at the 48th District Court in Bloomfield Hills. Pick up no new criminal offenses. And I understand you're self-representing yourself here today. The court will set a bond in the amount of $1,500 cash surety, no 10%. Sir, do you understand your bond? What I read off to you, your bond conditions?
Yeah, I understand all of that, but all of that.
Okay, now I'm gonna take your questions right now. Thank you very much. So, what question do you have for the court?
Can I place my status on the record, sir?
Absolutely, sir.
Okay, I'm Roman Curtis Kemp-Beal. I'm a natural person in full life, in propria persona, sui juris ser habitus. My nationality and citizenship being Moorish American national, unconditional heir, apparent vessel for the Moroccan Empire. I come at Northwest Mexum, at North America, North Gate, Turtle Island. I come under protection by way of Treaty of Peace and Friendship, 1836, between the United States Service Corporation and the Moroccan Empire. I also would like everybody else that's involved with this matter to place their status on the record, and so that it can be noted. And also, I'm not representing myself. I'm presenting myself. Not only that, I'm not standing a surety to Roman Curtis Kemp-Hill in all capital letters, ins legis, corporate entity. So that be noted for the record, please, sir. I also reside in domicile at. That's my address. That's my home. The defendant, witness, or whoever that is, Marissa, she doesn't live there, and so that's where I was kidnapped from. That's my home, sir.
Okay, and I will allow you to go back there one time and one time only with a police escort to obtain some minor personal property. That's with a police escort only. Otherwise, you cannot go back to that location. You have another court date coming up. Your next court date is going to be your pretrial date. That date will be provided to you prior to you bonding out. If not, you're going to have to contact the 48th District Court in Bloomfield Hills. Other than that, best of luck to you, sir. Officer, we're all set here. Thank you very much for your time.
If I could, Your Honor, we would like the refusal of the booking process that he not be released until that is completed.
Absolutely. He must submit, as it relates to the booking, he must submit to the booking processing in this information, including fingerprints, which is the biometric data. He must provide that information prior to release as well. You're all set, officer. Thank you.
So I'd like one more thing, sir. I'd like to invoke my treaty right to consular jurisdiction. I've been asking someone to be that's competent in the notification and access manual, and I haven't been given that right. My rights have been violated as far as all of that's concerned. Also, so
okay, make sure you mention that to the judge when you see the judge. So thank you very much, sir, for that. And officer, we're all set.
Thank you, Your Honor.
Okay, must submit the biometric fingerprint.
Last week, the out of custody pretrial because he wasn't able to get to Panama City.
Okay. Come on up, Mr. Williams. Okay.
Judge, he had been offered a pretrial intervention. We had supplied that to him, and I'm not sure what his intentions are. All right.
You understand a pretrial intervention is an agreement you have with the state that's basically supervised by the probation and parole, and then the case is dismissed if you successfully complete the that term. Could you repeat it? Pretrial intervention is a program that's offered by the state, and it's supervised by the Florida Department of Corrections. It's like probation, but it's not probation. It's an agreement that if you successfully complete the pretrial intervention, the state drops the charges against you.
I spoke with my public defender and he gave me the terms and the things that I have to do, and I didn't agree with him.
Okay,
And I don't understand.
sir?
I don't understand. So like the charges would be dropped.
If you successfully.
If you did all those
You have
terms.
to abide by those terms and conditions, and the case would be dropped.
Could I ask a couple questions?
You ask Mr. Meredith.
I did. I mean, I spoke with him shortly. I didn't really get all I really spoke of, what we went over was the terms.
We had several phone conferences that were scheduled.
Yeah, we missed a lot due to the time difference.
Sir?
I said, but we missed a lot due to the time difference.
He was on Eastern time and he would call an hour late.
I mean, a pretrial intervention is about as good as it gets. If you can take it or not take it, are we ready to set it for trial?
Yes, sir.
I don't want to do trial.
Well, then Mr. Meredith has done exactly what he's supposed to do for you. He's got the very best deal worked out for you. If you abide by the terms and conditions of the pretrial intervention, the state will dismiss the charges.
So the charges are brought upon me are by the state.
Well, who do you think brought them?
I thought I had a party.
Huh?
I thought it was an injured party.
The injured party, aren't they dope cases?
What is the jurisdiction of it? Is it criminal or
I
civil?
don't think you're near as smart as you think you are.
I'm just asking
I can
questions.
tell you not. Your possession of a controlled substance, giving false name, causing adverse effect. I guess there could be a victim on that. And resisting officer without violence. So, I don't know anything about the case, but it looks like you might have got a false, gave somebody else's name.
You just told me that the state was the.
The state's the only person who can charge you. Nobody else can charge you. It's the
Oh.
state. The victims can't charge you. They're just the alleged victims. They can't charge you. They can't do anything except make a complaint. But you've got offered a pretrial intervention. If you do the pretrial intervention, the state will drop the charges against you. If you don't meet the pretrial intervention, you come back to court and you start your defense again.
I don't wish to argue the facts.
Let's set it for trial.
Yes, sir.
Let's set it for May 5th at 8. Let's set it for June. What was that June date? June 2nd at 8:30. And it will be May 23rd.
Yes, sir.
At 1:30 for trial management. And if you change your mind and want to enter the pretrial intervention, you probably need to discuss that with Mr. Meredith. But remember, he's on Eastern Standard Time. Okay?
I'm on
He's
Central.
Central Standard Time. You're on Eastern Standard Time. Okay?
This courtroom drama unfolds with the kind of tension you can feel through the screen. Two separate hearings, two defendants, and the same strategy that we've seen time and time again: claims of being a sovereign citizen, arguments about jurisdiction, references to obscure legal theories, and absolute confidence that the court has no power over them. What happens next is a powerful reminder of how the legal system actually works. The first case begins with a man standing before the judge on serious domestic violence charges. These are not minor allegations. The court is dealing with accusations that carry real consequences, real victims, and real legal weight. But instead of addressing the substance of the charges, the defendant immediately shifts the focus. He begins declaring that he is a natural person. He says he is a Moroccan-American national. He refers to himself as an unconditional heir apparent, and invokes the Treaty of Peace and Friendship from the 1800s as if it shields him from prosecution. He speaks confidently, as though these words alone should end the proceeding. The judge listens, but there's no visible reaction of agreement or confusion, just calm control. The court does not engage with the historical references. It does not debate nationality claims. Instead, the judge proceeds with the hearing exactly as the law requires. When the defendant refuses to enter a traditional plea, the judge enters a not guilty plea on his behalf. The process continues. Bond is discussed next. Given the nature of the charges, the court imposes strict conditions. There will be a no-contact order with the alleged victim. He is not allowed to return to the shared residence. These are standard protective measures in cases like this, designed to prevent further conflict while the case moves forward. The defendant attempts to pivot again, insisting that he does not consent to certain procedures. He questions the court's authority to require fingerprints. He resists the idea of submitting biometric data as part of the booking process. But the judge makes it clear, compliance with booking requirements is not optional. Before any release can occur, fingerprints and processing must be completed. Personal disagreement does not override procedure. Throughout the exchange, you can sense the growing tension. The defendant continues repeating variations of the same themes: jurisdiction, status, sovereignty, while the judge continues moving the case forward. There's no dramatic argument from the bench, no raised voice. Just firm adherence to the law. And that's the key detail here. The courtroom does not operate on belief. It operates on statutes, precedent, and procedure. The defendant's strategy appears designed to challenge the foundation of the court's authority itself. But in practice, those arguments do not pause proceedings. They do not derail the case. They simply get noted and ignored. As the first hearing wraps up, the outcome is clear. The charges remain. The bond conditions stand. The defendant must comply with booking. The court calendar moves forward. The strategy that was meant to dismantle the process has changed nothing. Then comes the second case. This time, the tone is slightly different but the theme is the same. Another defendant stands before the judge. He has been offered something that many defendants hope for, a pre-trial intervention program. This is an opportunity. If he successfully completes certain conditions, often classes, supervision, or community-based requirements, the charges could be dismissed. No conviction. No trial. It's a path forward that avoids a permanent mark on his record. But instead of accepting the offer, he resists. He says he doesn't agree with the terms. He questions the court's jurisdiction. Again, he implies that without his consent, the case cannot proceed. He speaks as if agreement is a requirement for prosecution. The judge quickly clarifies the reality. Criminal charges are brought by the state. The state decides whether to pursue them. A defendant's personal agreement is not necessary for a case to move forward. If he does not want the intervention program, that is his choice, but the alternative is trial. The exchange becomes increasingly revealing. The defendant seems to believe that by refusing to acknowledge the court's authority, he can somehow invalidate the proceedings. But the judge does not entertain that premise. Instead, the court sets the matter for trial. And just like that, an opportunity that could have resulted in dismissed charges disappears. What makes both of these hearings so compelling is the contrast between confidence and consequence. Both individuals speak with certainty. They rely on phrases and theories often circulated in sovereign citizen circles, claims of special status, historical treaties, arguments about corporate government structures, or the idea that courts only have jurisdiction with consent. But inside an actual courtroom, those claims consistently fail. Judges are trained to deal with these arguments. They do not debate them at length because legally, there is nothing to debate. Courts across the country have repeatedly rejected sovereign citizen theories as frivolous and without merit. The law does not recognize self-declared immunity based on alternative interpretations of citizenship or historical documents taken out of context. And that's exactly what we see here. In the first case, invoking nationality and treaty language does not erase domestic violence charges. In the second case, Refusing to agree does not stop prosecution. In both situations, the court moves forward with procedure unaffected. There's also something deeper happening beneath the surface. These strategies often create the illusion of control. For someone facing serious legal trouble, claiming sovereignty can feel empowering. It shifts the narrative. It reframes the defendant not as someone accused, but as someone resisting illegitimate authority. But empowerment in theory does not translate to success in court. In fact, the opposite often happens. Time that could be spent negotiating favorable terms is lost. Opportunities like diversion programs are rejected. Judges may grow less patient. And ultimately, the legal exposure increases. You can sense the frustration building throughout these hearings, not explosive frustration, but the quiet frustration of watching someone make their situation harder than it needs to be. The law provides structured options: plea agreements, diversion, bond conditions, trial rights. But it does not provide an escape through semantic arguments about identity. Another important moment comes when the judge emphasizes that the state is the entity bringing charges. This is fundamental. Criminal law is not a private dispute that disappears if one party refuses to participate. It is the government enforcing statutes enacted by legislation. The machinery continues operating regardless of personal philosophical objections. And that's why these courtroom exchanges feel so intense. There's a collision between belief and reality. Between internet theory and legal practice. Between absolute confidence and unmovable procedure. Neither judge resorts to theatrics. There's no dramatic shouting. Instead, there's calm repetition of the rules. Pleas are entered. Conditions are set. Cases are scheduled. Compliance is required. For viewer, it becomes a powerful demonstration of how the justice system responds to sovereign citizen arguments, by proceeding as if they were never made. By the end of both hearings, the outcomes speak for themselves. The first defendant remains bound by strict conditions and must comply with booking. The second defendant forfeits a potential dismissal and heads toward trial. The legal system continues forward unchanged. And that may be the most striking takeaway of all. No matter how elaborate the claim, no matter how confidently delivered, no matter how old the treaty cited, the courtroom runs on established law, not alternative interpretations. These hearings serve as a reminder that while anyone has the right to represent themselves and speak in court, strategy matters. Understanding how courts actually function matters. Because once proceedings begin, belief alone is not enough to alter the course of a criminal case. What we witness here isn't just legal drama. It's a lesson in consequence.